the law, as manifested through judges and in our legal system, may not have had the level of sophistication to appreciate that slavery was a health issue as well on some level, right? I mean, because they did not consider slaves to be anything other than a commodity at that time. And so the idea of the health of this commodity is, the same way that you would talk about, I guess, depreciation for a piece of equipment, et cetera, et cetera. But when it came to specifically questions of health, this concept that the welfare of the people is paramount. Can you talk about in conflict with what? I mean, what it's like, because on some level it seems like obvious, of course, that the welfare and that's probably a broader meaning than just health of the people should be paramount, but, specifically relative to what sort of a strain that has existed within the context of the law.
Well, it's a great question. And I think it's important to understand that I think we often think of the 19th century as this period of laissez-faire, rugged individualism, no regulation. People did their own thing. People took care of themselves. And in fact, that's not true, right? That in fact, the earliest, especially the antebellum period, was a period of significant regulations. Now, we didn't have the kind of complex bureaucracies, and we didn't have the complex federal bureaucracies that we have today. But all kinds of manner of things were regulated, from the quality and the weight of bread to vaccine mandates going back to the 1820s, sanitary measures. And all of these different laws were not assumed, especially if I'm going into the antebellum law, to be in conflict with what we today think of as individual rights, including property rights, because people simply didn't have rights to do things that were considered detrimental to the common good or the public's health. And so you had just a lot of regulations. They would come and go. They would be more or less effective, more or less scientifically grounded. But
were these local or federal, or were they local that was edified by legal tests on a federal level? Where did these emanate from, these regulations?
In the antebellum period, or pre-Reconstruction, they were mostly state and local, right? You did have some federal, but not a lot. It was mostly state and local. Localities and sometimes states enacted quarantines. They regulated businesses. They took care of sanitary measures. You just had a sort of a wide swath of One of the terms that was often used is you had a well-regulated, well-ordered republic, right? A well-ordered state. And these measures, for the most part, were just not seen as conflicting with individual rights, because the idea that there were rights against the public, very common idea today, right? I mean, the idea that the government does something, it violates my right, I'm an American. This idea that our freedom comes prior to the well-being of the public was not a very well-established, it was still nascent. Before the Civil War. It begins to develop during Reconstruction. And so then the first time when you start getting the Supreme Court really beginning to develop the relationship of constitutional rights, particularly the rights protected by the by the Reconstruction Amendments, and individual rights, and public health. But this is not there at the beginning. And what has happened now is we've gone to a place from sort of no recognition of individual rights, or barely any, to a place where, as I describe in the book, individual rights continuously trump the public's health. and not just trumpet in individual cases, but leave governments increasingly incapacitated to respond to the social determinants of health and even to pandemics. So we're kind of left to be on our own because our law now makes it increasingly difficult for governments to respond.
And I think what's important for people to understand is you're talking about the law as it's interpreted, because the laws have not changed in this regard. When we talk about the constitutional amendments in the wake of the Civil War and Reconstruction, constitutional amendments, they haven't been updated.
Right.
It is really the interpretation. So describe to me like how 13th, I presume mostly 14th Amendment, 15th Amendment, how they developed. It's almost like they were upended. And I wonder if it was also like, what is that a function of? Because one of the cases that you sort of really sort of pivot off of is the Massachusetts Jacobson case, or Jacobson versus Massachusetts, which I think came out of Cambridge, Mass. Tell us about that case, but then if you could, like, track how the 14th Amendment gets sort of reversed. And I wonder if also, these amendments, I'm putting too much on your plate right now, but Justice KBJ made the point in a case about affirmative action that these amendments were specifically meant not to be colorblind, that they were in fact, color conscious. They were made to, in many respects, take freed slaves and make them full citizens, because they were a specific cohort. But that wasn't. It's more than implicit, but it's not quite explicit. And so that failure of making that explicit gave room for the 14th Amendment to be sort of twisted in some ways that ultimately lead to where we are now. But I'm sorry, go maybe start with Jacobson.
Yeah, so Jacobson is from 1905, and it dealt with a vaccine mandate. The state of Massachusetts gave local boards of health the authority to impose vaccine mandates. And these mandates were much more intrusive in some way than the ones we're accustomed to. These were anybody walking in the city of Cambridge had to be vaccinated or show proof of vaccination or pay a fine, but it was a criminal fine. And there was a lot of resistance at the time. There was an organized anti-vaccination movement. Some things are new and some things are not. And organized resistance to vaccines go way back. And Jacobson and other co-defendants refused to pay the fine. They were charged. They defended their case in criminal court, arguing that the Constitution gave them the right of liberty and that the mandate violated their rights. And the case eventually the state courts disagreed with Jacobson, and the case eventually made its way to the Supreme Court. And the Supreme Court, in a 7-2 decision by Justice Harlan, affirmed the state's power to mandate the vaccine. And for a long time, Jacobson has been one of probably the most cited, the most relied upon case about the government's power to protect health, especially against communicable diseases. What's really interesting about Jacobson is that it's at this moment where the court is both looking backwards to the older jurisprudence and forward to the newer jurisprudence. And the backward jurisprudence, which is, I think, most of the opinion, doesn't ask what is the nature of Jacobson's right. Does he have a fundamental right? Like, that kind of language is not accessible to the court in 1905. Jacobson himself was a pastor. He had religious objections to vaccines, but it wasn't a religious liberty case. It was just the 14th Amendment protects me. And the court said, no, the 14th Amendment doesn't protect you. because the state has the right to make reasonable public health regulations. The liberty that you have does not only exist against the state, but Harlan says real liberty depends on law. It depends, right? The liberty, so there's this theory of a social contract in Jacobson, right? You get benefits from being in a society where others don't have smallpox, right? Your health, your risk of dying is a lot less because everyone's protected against smallpox. That's your real liberty. But Jacobson also foreshadows the jurisprudence that we are more familiar with and looks to the future and says, well, yeah, but there might be a sphere of individual liberty. And maybe in some case, not this one, but sometimes the state might violate that. And if the state acted arbitrarily or capriciously or oppressively in a particular case. So it foreshadows where the court ends up going in the second half of the 20th century with this idea of individual autonomy. But what I want to stress is pre-Jacobson, that idea of bodily autonomy, that I get to do with my body what I want to do, that's just not really in our jurisprudence.
And I mean, it also strikes me that forward-looking jurisprudence that you're talking about is forward-looking only in the sense that it was perhaps opportunistic for those in the future who wanted to develop that right, because it seems to me it's just as easily argued that the reason why they also cite the idea that there are instances where you do have a certain amount of freedom is probably, to my mind, looking back on the fact that we are 30, 40 years out at that point from having enslaved people. And that it could be like, if we were really, harming your individual liberty that had no sort of like a benefit to the greater good, that would be the issue. But I guess it's irrelevant as to what the intent of the court was at that time, and more relevant as to how it's used in the future. But where did this concept, and we're getting into sort of like negative rights versus positive rights, and if you could maybe explain that idea, and where did this start to creep up? They saw that little opening in Jacobson, but what happened in society and the law, which I think are, in politics in the law and in economics in the law, that created this new development in our society?
Right. So first, what are negative rights? To oversimplify a little, we say negative rights are freedoms from the government, right? Keep your hands off of me, government. I want to do what I want to do, and the government can't stop me, right? And that idea sort of assumes people are isolated from the government, isolated from society. They have their own preferences. They have their own autonomy, right? It's a very common view. Positive rights are rights, sometimes we would say are rights to benefits, but not just benefits, right? Rights to health, rights, but not just health insurance, right? Right to live, things that we can't, it's the freedom that we get from living in a society. It's the freedom that we get. I can do my own thing, not because I'm left alone, but I can do my own thing because I'm not going to die of smallpox, because smallpox isn't prevalent all around me. It's not raging. So where did these rights come from? I mean, liberal theory, right? You can see it in John Stuart Mill. You can see it arising with the rise of contemporary, capitalism and the movement away from a more regulated economy. We can also, and you point to Civil War and Reconstruction. I also try to make the argument in the book, right, that in fact, the reducing prevalence of contagion makes it easier for us to believe in our independence. So in the early 19th century and earlier, communities were just completely, repeatedly devastated to degrees that we cannot understand by cholera, yellow fever, smallpox, these waves of epidemics would come through. And people were really, they didn't really understand where these diseases came from. But they also did understand that most people could not protect themselves, right? In that world of contagion, our interrelationship is, I think, easier to understand than we see it today. So what starts to happen post-Reconstruction, and I think, here I might differ with you a little, is less the looking back to understanding what the Reconstruction framers meant, although maybe Harlan did, but it's more you get this increasing move towards one, business interests challenging and trying to use the 14th Amendment to limit state regulations as we move to a more capitalistic society. And at the same time, a movement away from public health to seeing health in an individualistic term. Go to my doctor when I'm sick. I don't need the state to regulate stuff. I go to my doctor when I'm sick. And you get to this more and more increasingly individualistic approach. And we begin to get more and more emphasis on the development of rights against the state by freedom of speech, freedom of religion. These weren't, we can point to them in the Constitution, but they didn't apply against the states in 1905. And so we get this churn, and you said earlier, upended. I think what we really get is a flip. And so today, instead of asking what's the state's interest as the first question, courts say, what's the individual right? Religion, speech, Second Amendment, right? We focus on our rights, not the state's interest.
And this happens, and I mean, as you say, the thing about contagion, it never really occurred to me that this is a much more sort of like devastating force in that era, that people are willing to realize that it's beyond an individual's control as to whether they're any individual, whether they're rich or poor, or whether they, they don't have the opportunity to work at home. So it's like, if you're going to work, you're going to be working, you're not going to be doing it over Zoom. I would imagine too, things like, the Great Fire of Chicago, and like it gives an example of, we really need to be communitarian if we're going to fight these things. But as technology develops, as wealth disparity increases, there are certain cohorts are like, I really don't need it. I can have my own fire department if I really wanted to. We in this gated community, and I can go in on Zoom, and I don't need to have this communitarian response. Because I mean, you say this develops in the in that early 20th century. And this is obviously like the sort of a big robber baron era, but then we go into an era of during World War II, where we have Roosevelt really espousing the idea of positive rights in his Four Freedoms speech. It carries a lot of weight. But then coming out of World War II, do we see any type of like legal cases that mark this transition to where we get into, I don't know, the past 20 years, where this idea of like religious liberty and like even movements of corporations to say like, you're telling us to have our employees wash their hands, but you're imposing on our First Amendment rights to not tell them to say that, to do that.
Yeah. So, the movement towards individual rights started long before the Roberts Court, long before COVID, right? And, we see it in the social movements of the 60s, challenge authority, individual rights, allow for dissent, recalibration, even in the Warren courts against some of the very problematic aspects of the early jurisprudence. And that was in accord with Roosevelt's and the New Deal agenda. Where I think things sort of go further is it's relatively recent that the court starts applying those individual rights as trumps what I would call core public health powers, right? So, you used to court, even back, the Rehnquist court is clear, no positive rights, First Amendment is protected, free speech. We see this in the second half of the 20th century. But now we get it even to, in the middle of a pandemic, religious liberty overrides law, stay-at-home laws, right? Religious liberty overrides laws to close schools. So now we go from recognizing those rights and rejecting the idea of positive rights, which goes back to the Rehnquist court, to now going to the place where we say, even in a pandemic, where the court says states, can't, at least not the Supreme Court, but some lower courts reading the Supreme Courts, can't have vaccine mandates without allowing anyone who has a religious exemption to opt out, right? So now we're kind of going, and that's what you said earlier, the flip. We've gone, from perhaps overly deferring to public health laws to now kind of giving them almost no weight if someone has an individual claim that the court recognizes.